Welcome to everyone here and those who are joining us online. I am Mara Rudman. I direct the Ripples of Hope project here at the Miller Center at the University of Virginia. And I am so excited for this conversation. I've been talking to people who are not here, I hope many of them are online, about how much I was looking forward to being at the table with all of you. It's truly an honor. You're all distinguished jurists from Brazil, from Ghana, from Ukraine, and from the United States. And yes, I did that in alphabetical order. I want to do just a quick bit of housekeeping before we dive in, which is to say that we will have a discussion, for those of you who are regulars, you know, among the five of us here at the table until about noon, and then we will have 15 minutes for questions from the audience. And we will have a roving mic in this case. I'm going to ask, as always, to try to maximize the time for those at the table to respond, so questions as opposed to, and short questions, ideally, as well. And for those online, you will have some capacity to put questions, I think, in a chat or something else that someone will be explaining, or you'll be able, hopefully will be obvious online, and those will be fed to me as well. So we'll try to do a combination of questions from those here in the room and those who are joining us virtually. So this event is co-hosted by the Miller Center, the Ripples of Hope project at the Miller Center, the Presidential Precinct organization, and the U.S. Chamber of Commerce Foundation. I want to thank our co-hosts for teaming up with us on this and welcome not only our panelists, but the entire cohort of judges who are joining us today, the judicial fellows of the Presidential Precinct project. I just learned this is the wind-up event of the 2 weeks they've spent here in the United States. So I'm that much more honored that they made time for us, and also that we get the wealth of experience not only from your service in your countries, but also from the interactions among all of you over the past couple weeks. I'm going to ask each of our judges to briefly explain their benches or roles as they're addressing a question to the extent that it's relevant. You all have handouts that give you a brief description of the court so you can see where they sit, the court system in each country and the courts that they are serving on, or in Jamie Baker's case, on which he served, the Military Court of Appeals. So I will ask an initial question to each. I'm going to ask their pardon at the front end for not referring to them by their formal judicial titles during this discussion. They've given me permission to do that. Not a practicing lawyer, but have enough of a lawyer still in me to know that you need to ask judges before you do something like that. So,
and you're not standing, I might know. When you address the court, please stand.
So may it please the court. Let's dive into discussing the role and challenges for the rule of law in safeguarding economic and national security around the world, with particular emphasis on impacts in the United States, Brazil, Ghana, and Ukraine. And I will say, I'm going to put the first question to Jamie Baker, but I will say that while each of these countries has their own unique challenges, one of the things that's already become apparent in the conversation we were having with one another beforehand is that there are a number of lines of similarity in what judges are facing all over the world, including the United States and in these four countries in particular. So with that, Jamie, let me turn to you and ask a little bit of a compound question. Given your position as the judge and the chief judge on the Military Court of Appeals for a number of years, and previous to that, and full disclosure, Jamie and I worked together serving on the National Security Council staff for President Clinton, where Jamie was the legal advisor at the National Security Council when I came in. And I learned a great deal from him then. I'm sure I'll continue to learn from him here. So I'd love, Jamie, for you to tackle the role of the courts in national security, and particularly why adherence to the law of armed conflict, with which I know you're intimately familiar, leads to better national security results.
Thank you, Mara. And thank you to the Miller Center. And let me say how honored I am to join this international bench. So it really is a pleasure to be here. So as Mara indicated, I sat on the United States Court of Appeals for the Armed Forces, which is one of the two standing courts in the United States that deals with national security on a regular basis. The other is the Foreign Intelligence Surveillance Court. It's not, in fact, the standing court. It meets as needed. But those are the two courts whose jurisdiction is entirely in the area of national security. The federal district courts in the federal appeal system also deals with national security issues, as we see every day in the United States now, but that's done on an episodic basis. Courts don't choose the cases that come before them, the plaintiffs do. And so so in this sense, the federal judiciary is the third branch of government when it comes to national security, the two political branches being the primary national security branches. However, the federal courts play three vital roles. One, they obviously are the guardians of constitutional rights in the United States. They hear criminal cases. My court was a court entirely of criminal jurisdiction. Federal courts hear espionage cases. They hear all the full range of criminal cases, including cases arising out of the law of armed conflict. And as we've seen most recently, federal courts decide questions regarding the executive branch's authority. Let me highlight two matters in this instance, and then I'll get to the second part of your question. One of the questions that all federal courts have to ask when a case comes before them is, what is the role of the court? And there's a tension now between the executive branch. There's traditionally a tension, but there's a tension now that is quite pronounced between the executive branch and the courts about what the role of judges is. Is it to just decide questions of law? Is it to decide questions of law and fact, or is it to stay out of the way? And it is traditional for courts to present some measure of deference to the president and especially to the president on matters of national security. The question is how much. And I would commend to the audience the recent decision by Judge Immergut in the Federal District Court for Oregon in Portland, Oregon, where she made it clear that while she would afford some deference to the executive branch, she would nevertheless require that there be a colorable assessment of the facts and the law within a range of honest judgment. So she would defer, but there had to be a colorable assessment of the facts and the law within a range of honest judgment to which she would defer.
And Jamie, I just point out she was appointed by President Trump in his
She was
first term.
appointed by President Trump, and she had worked for independent counsel Ken Starr. There is no question about her bona fides as let me restate that. She cannot be properly labeled an activist leftist judge, which of course we don't have in the United States. We just have federal judges. So that's one tension. Another tension is who decides the law. And as everybody in this room knows, since 1803, thanks to John Marshall, the courts ultimately have decided what is the law. That's Marbury v. Madison. But what we're seeing now is a debate over who ultimately decides the law in the executive branch, and is that determination free of the judiciary's determination? That's a fundamental question about how law works in the United States. It's not a political comment, it's an observation about what is going on. One of the things Judge Immergut said was that we live in a country of constitutional law, not martial law. And one of the core issues that's been put on the table recently is the question presented by the Posse Comitatus Act and by one of the founding principles of the Constitution is what role, if any, should the United States military, active and guard, play in civil affairs? And this is a question that is being debated in the courts, decided in the courts, reviewed in the courts, and it's a question that will continue on. I'm not going to go into it right now because I want to stay on the clock and get to your second question, or the second part of your question, which was why does law matter and why should we follow it in the United States military, for example. 2 weeks prior to the full-scale Russian war of aggression against Ukraine in February 2022, I was asked to give 6 lectures in Ukraine. And they asked, what's your topic? And my topic was everything I would want to know if I was about to be invaded by Russia. And what I tried to convey was everything I had learned in 7 years on the National Security Council that might be helpful. So I talked about intelligence, intelligence oversight, presidential command and control, crisis decision-making, the law of armed conflict, and war crimes. And after each presentation, and the audience consisted of members of the government, after each presentation, I was asked the same question over and over again. Why does law matter when we face an existential risk? And I was ready for the question because I'd heard it before in the White House Situation Room every time there was a crisis.
I also have some idea of who asked more often than others.
And so I had a slide with 16 talking points on it, since judges always speak in 16 talking points. But I will spare you all 16. I'll highlight 3 and then I'll stand down. George Washington, the great general, but more even the great constitutionalist, he's the one who first said, the difference between an armed mob and a professional military is adherence to law and good order and discipline. Professional armies win wars. Armies that don't follow the law lose wars. They're armies of war criminals. Second, recruiting. Do mothers and fathers want their sons and daughters to go into the United States military to go off and commit war crimes? Of course not. It's an essential ingredient following the law in a democratic army to recruitment and popular and public support for the military. The U.S. military is the most respected institution in the United States, public institution in the United States, by far, and it's the only public institution in the United States well over 50%. It's the only public institution over 50%. I think there are 3 reasons for this. 1, just patriotism. 2, the United States military has been apolitical since the get-go, putting aside the Civil War for a second. But that started with President Washington, or General Washington, at Newburgh. But the United States has a long-standing tradition of being apolitical. It's the most diverse organization I've ever been in, and it's diverse in every way, including political outlook. And then the third reason, the United States military follows the law. And that's one of the reasons that it remains the most popular and supported public institution in the United States. Shame on any politician of any party who would seek to undo that. The United States military is a national gem. And then the last of the 3 out of the 16 talking points I'll share with you. The others are available on tape, and I do birthday parties as well. Which is, we've seen in history over and over again that violations of the law of armed conflict cause you to lose public support and undermine the will to fight, Miley, Abu Ghraib, and they strengthen the will of the opponent. See Ukraine. Ukraine has a tremendous will to fight, and in part it's because Russia has committed well over 150,000 war crimes. So those are reasons why. Oh, and then by the way, the leading talking point with the government of Ukraine is, if you want NATO and U.S. weapons and intelligence, follow the law. So that's another reason you do it. When the United States is perceived as not following the law, our allies don't share information with us. If you take the drug war, for example, if you're doing things that others perceive as outside the law, they're not going to share information about how to better interdict drug vessels. So I think I've had my say. Was that
Yeah.
in the ballgame of what you?
Yes, and we'll come back.
Okay.
Because, and that's sort of the goal here. Agnes, I'm going to come to you next. You serve on the High Court as a High Court Justice in Ghana. Ghana is not alone, I think, in challenges with public corruption. That is something that, again, all 4 countries at this table share. I want to underscore that. All 4 countries at this table share that challenge with public corruption. And when and how it comes before the courts is an issue, and whether it affects the courts. And So I would love to hear from you about the challenges courts face with public corruption in Ghana and what has been done there. What have you been involved in or others in terms of tackling it?
Thank you, Mara, for the question. Corruption is a key issue in Ghana. If you look at the World Justice Project Rule of Law Index and the Afrobarometer survey in Ghana, always corruption is at the top. So we are all aware of the situation, and then how the issue is how best we can address the issue of corruption.
I just want to pause you for one moment, because you referenced the World Court of Justice Index. It's fascinating for anyone who looked at the New York Times article on October 1st on challenges around the world. I will just say a quick cheat sheet, because I looked at that and noticed the order of the United States comes out 26th, by the way. So we're not at the top in terms of adherence to rule of law. Ghana is next, then not in straight order, but it's the United States, Ghana, Brazil, Ukraine is the bottom of that group, just kind of for awareness, but please.
So in terms of the legal and institutional framework, we have enough laws because Ghana has signed on and ratified the United Nations Convention Against Corruption and also the African Union Convention on Prevention and Combating Corruption. So in terms of legal and institutional, we don't have much issues. The issue is the effectiveness of the law and then the institutional framework in Ghana. So we set up what is called the Office of Special Prosecutor to address the issue of public corruption in Ghana. And there has been a number of challenges. And for the court, our main duty is to prosecute cases of corruption as fairly as possible and to sentence and also to make sure that we assist in asset recovery, because it is not enough to just impose sentences. We have to go further to confiscate assets which have been accrued as a result of corruption. And then also, in terms of our international obligation, for the court, we extradite people involved to other countries, and we also cooperate in terms of mutual legal assistance with other nations for investigations and then prosecution and any other issues that may come up. There has been a number of challenges that we have faced. One is public confidence in addressing corruption. The public feel that usually issues of corruption are targeted at the opposition party, and then not much is done to address corruption within the government itself. And also, we also have the issue of corruption within the judiciary itself. To be able to address public corruption, it means that we should be able to address corruption within the judiciary, because that is the only way the public will have confidence in the independence of the judiciary to be able to address the greater corruption in society. So due to the lack of public confidence in the judiciary, there has been a number of reforms. So we have anti-corruption.
How recently? Over what period? When you said number of reforms? Like 2 years, 10 years?
We have had a number of reforms which have been slow and uncoordinated. But for 2024, for instance, we had what we call the Leading Justice initiative by our Chief Justice, aimed at addressing some of these challenges that we are facing to build confidence in the judiciary. So based on that, we put up what is called the Anti-Corruption Action Plan to address corruption within the judiciary itself. And also another major challenge to addressing public corruption is the issue of slow proceedings. Most of the time, cases before the court take a long time to conclude. And once they drag, the public also lose confidence in our ability to address some of these issues. Another critical matter is also the use of plea bargaining in addressing public corruption. Although there is a general consensus that public plea bargaining is good for the entire society, people feel that for something as serious as public corruption, we should not be using plea bargaining, because it will be like you just amass wealth from the public and then you can just go and negotiate anything, and then you are not, no deterrent sentence is imposed on them. Another critical issue is also the entry of what we call nolli prosequi. That is the power of the Attorney General. Sometimes they gather evidence, everything, the matter is filed before the court. It can even go as far as to the level of maybe at the close of the case for prosecution. But because of this power that they exercise, they can enter what we call nolli prosequi to end prosecution at that stage, and the court cannot question the exercise of this power. So it's a major challenge that we also face. So by and large, in Ghana, we acknowledge that yes, it exists. We have the legal and institutional framework to deal with public corruption, but the issue now is how effectively we can have these laws and then institutions to perform their duties. Thank you.
Yes, please.
Research has shown that countries with independent judiciaries are more attractive to investors, especially from the states that themselves have a strong and independent courts. Independent courts, they create a level of playing field, reducing the risk associated with corruption and favoritism. In Ukraine, the lack in courts, the lack of trust in courts has long been a barrier to foreign direct investment. For example, before 2014, a lot of international investors relied on international arbitration rather than national courts. That's why Ukraine launched a significant reforms, such as establishing a high anti-corruption court and a transparent process for judicial selection with international participation.
Were these reforms put into place before Russia's invasion? Or
Yeah, it starts from 2014.
Okay.
And it's on the way until now. Also, Ukraine is, while these reforms are still ongoing, they send a clear message for all investors and global partners that Ukraine committed to building institutions that can guarantee a fair and predictable justice.
So can I ask a follow-up on that, and then come to you? I was in Ukraine in April of 24 as part of service on the U.S. National Defense Strategy Commission. Yeah, and we went to visit a number of new industries that had been built up specifically to help in the fight against Russia. A lot of drone-related factories. I am curious about whether you have seen during the course of the conflict an increase in foreign investment, whether the courts have had to, whether this issue of the reforms you've put in place have been effective in allowing more foreign investment into the country to support some of these industries. Is it better? Is it worse? Is it the same?
What exactly do you mean?
That how have the reforms that were put in place in 2014?
Yeah.
Have they been effective?
Yeah, have they been effective in playing out? Given
And encouraged investment?
Yes,
Yeah.
yes, for sure, because as I said before, we have a huge judicial reform. Also, we establish a new organization such like National Anti-Corruption Bureau and a specialized anti-corruption prosecutors, and also high anti-corruption court. And nowadays, it's like 10 years. We have 10 years experience, and they have great results. They have high public trust, especially from the young generation. They trust a lot. So I'm sure that they're really effective. Yes.
Could I
Yeah,
ask
please.
both Agnes and Igor just one bullet? Perhaps that's an inappropriate. One
From
talking
the security
point.
guy.
If you were to suggest one reform to make for another country as a general matter, do this one thing, what would you recommend in terms of addressing corruption? Same question to you, Igor.
I think investment in the rule of law, independent judiciary is key, because that can be an antidote to corruption, because once the people feel that if we engage in this, the courts will not spare us, then they will stay away from issues of corruption. So for me, independent judiciary is key, and a judiciary that is well-resourced to tackle issues of corruption is key.
Thank you.
Diana?
I'm sorry.
Yeah, please.
I just wanted to add, because when we talk about corruption, and this was, very much discussed in famous corruption cases involving government that we had in Brazil, that when we have corruption by a public agent, there's always someone from the public sector willing to corrupt. So, so I think addressing corruption is a matter of the rule of law. You have to enhance rule of law, compliance, oversight, but we have to enhance civic education. Okay,
Yeah.
because the public sector plays a vital role in addressing, the private sector
Yeah.
plays a vital role in addressing corruption too. And this is part of civic education.
That it is a common thread.
Yes.
From my point of view, of course, rule of law and judicial independence is important things, but we have to prevent corruption, and digitalization is a better way, because we are really good in it. We have like a Ministry of Digitalization that we try to do everything in digital way, to use it as widely as we can, and it helps to prevent corruption.
So can you explain that a little bit more to people? I assume it's part of, there's transparency or trackability or.
From 2019, when the new president was elected, it was established a new Ministry of Digitalization, and now this minister, the chief of this ministry, he is like a vice prime minister, and we have a special application on telephone, and you can use also your personal computer, laptop, tablet, or what else, and you can get any information from the state in digital way. It's transparent, fast, and cheap.
Yeah.
And also we have a special electronic system for the courts, and you can send any document to the court through your telephone. You can even sign it through your telephone. All documents, I don't need to have documents for my car, I don't know, passport and any else. All documents also is in my telephone. It's rather modern thing. It's very useful, and a lot of especially young people, they do not have paper documents at all. Before, you need to stay in a long queue, yes, to get any paper from the state. It's that's why it was like a there is small corruption. You need to
get further, to get advantage and
to find somebody to make it faster, to get any document. But nowadays it's completely free, fast, and cheap.
Yeah, yeah,
You can get any document, just in 1 minute.
very interesting.
After the panel, I can show you how it's working.
We'll be jealous. Janine, that actually leads nicely into both, I know you've specialized quite a bit in technology issues. Brazil has been fascinating in what, as a country, it's done on that score. And I think you particularly have experience, background, and I assume experience on the bench as well, on the intersection between rule of law and economic security. So would love you to be able to explain to us a little bit where you see those connections in your experience, and if you have the opportunity, how that ties into some of the technology issues also that you've dealt with.
Okay. Oh, well, first, thank you, Professor Rudman, for having invited me to speak in this event.
I'm definitely Mara, by the way.
Mara. So I am honored to be here at Miller Center alongside, incredible panelists. And it's very challenging to speak about the rule of law tied to economic security and development, because as we know, there's a variety of possible conceptions about the rule of law. And also, there is not a single path to achieve rule of law principles when you research, worldwide experiences. So, what did Brazil do? How did it organize its framework since the fall of the dictatorship regime in 1988? To enhance economic prosperity, economic security, and how did the rule of law play a vital role in that process? So, well, although we do recognize, the variety of conceptions, and that's not a single path to it, we do know that the rule of law involves governance, and to that we have to consider legal, political, economic, and social factors and social reforms to achieve a greater standard of the rule of law. So with our new constitution in 1988, as we came from dictatorship regime, society had the worry to bring a lot of individual rights, not only to citizens, but to players in the market, in order to restrain the political power. So in that sense, we brought to our constitution some rights, like the conception of vested rights, which the protection of vested rights, and also the right that the imposition that government had to respect what I'm gonna say, you can follow up with me well, but this is obvious. But when you come from a dictatorship regime, it's not so obvious. So in the Constitution, there was a right that the government had to respect final judgment from courts, as a constitutional right. So and that plays a vital role in our day-to-day bench, because as it's a constitutional right, when contracts are challenged and we have problem in protection of property, enforcement, and because maybe a legislative branch or executive branch tries to overreach its powers, these rights play a vital role in a daily adjudication. So we also had, so this is part of our legal reform. We also had a great, important reform in 2004 in partnership with the World Bank. So that was a very important reform that addressed the judiciary, because we wanted, the World Bank wanted to make sure, and also Brazil, that our judiciary had full independence and a way, of course, apart from, we don't have political appointments for state and federal judges. It's a competition. We do exams. So we have several members from the bench from even lower class, lower income families, for instance, that worked hard, study hard, and do not have any political connections.
So it's exams and based on scoring?
Score,
of the exams, that's
yeah.
how
It's a
seats get
score, no
determined?
political appointment. Of course, you have to have references. It's a one-year exam with 5 phases. Very tough, very difficult. And at the end, when you're ranked during this process, you are, of course, you have background checks.
Right.
And also you go through psychological and psychiatric examinations, and lastly you have an interview with the committee, which is formed by senior judges. So we don't have outside intrusion in the pit, in the appointment of our judges.
Can I just ask a quick follow-up on that?
Yeah.
Does the same system apply for your Supreme Court?
No. And I'm going to talk about that in our challenges on the
Okay.
last round,
Okay.
okay? But, but the point is that until the appellate court, it's a career,
Yeah.
okay, at the first instance, and this applies to the state branch and federal branch, okay? We also have tenure until 75 years. Okay, and after that, you have to retire, but you retired with full pension.
Yep.
Because as a policy, it's a matter of policy. Our legal system understands that ideas have to recycle, and we have to apply precedents, but we also have to adapt to social change. So I think that's what our system imagine. So, and more important, that this was a subject that we discussed along these 2 weeks. Our judiciary has financial independence, because during this reform in the Constitution, it is written that it is the judiciary, the Chief Justice of the Supreme Court, that has to send the amount of, that has to request the budget for the next year for the judiciary to Congress. So he points out the amount that's needed. Of course, everything is reasoned. And although we may face cuts in Congress, do you understand that that conversation starts from a certain threshold when the judiciary has the authority to point out what is needed? So, and all the conversations on the political discussions in Congress discussing the funds of the judicial branch, executive branch, and Congress branch, it has to be reasoned, and we have a specific laws that kind of gives guidelines of, and of course we have to consider the tax revenue budget for the next year. But we depart from a certain threshold for the discussion, and that gave much more independence to the judiciary. But alongside, so Brazil's framework for economic development is worried in creating an environment that guarantees the independence of judiciary that will have the last say. For instance, when you have to enforce contract or to protect property, and even to analyze antitrust issues in markets. But alongside with that financial reform, we also had a huge reform in our civil procedure, and this was a very strong worry from the World Bank, because we used to have, let's suppose, 15 years to the final decision in a course, and how would an entrepreneur be open to invest in our country if our, trials last so long? So we had several reforms in our civil procedure to
Shorten.
to shorten, the timeline of trials, and this was something that helped very much, open the country to investments. But I said that, the pathway to the rule of law is not only legal, it's not only economic, but it's also political. So I want to bring here to the table a very specific trait of a Brazilian system regarding to elections. So, yeah.
We've noticed some rules of the courts in
So
elections there.
I think it's important because elections are oversight, who oversights elections in my country and also conducts election is a branch of the federal judiciary, okay? So as we have a career, as I said, we have no political involvement until the appellate level. It is our society, they have trust in our election system. So we have adopted the electronic voting, although everything can be tracked. Every vote can be tracked. In each voting center, we have a judge that is responsible for it, so anyone can petition if there is an issue. We have the presence of representatives of both parties in every voting sector, oversighting even the judge. Okay, so if let's suppose if it were here in the U.S., you have a representative from the Democratic Party and the Republican Party in the voting center. So
Which we generally have, just without a judge.
Oh, great. So we want to guarantee that there's no maneuver to hinder, the access of citizens to the voting center of the day of elections. So, and also during this, so because we think that election is crucial part of the rule of law, because society will have, even though they do not approve every law that is enacted, they will know that they were the ones that were responsible for electing those, congressmen. So maybe they're the ones that are responsible for holding them accountable in the next elections. And lastly, so legal, political, and what about the markets, right? So after the fall of our dictatorship regime, during the dictatorship regime, we had the government playing, working as a player in markets regarding to infrastructure. But after 1998, our constitution made very clear that markets are for private actors, okay? Because we don't want to, let's suppose, an investor to come invest in Brazil, and then when he wakes up on the other day, he sees government competing with him in the same industry with much more power. Nobody would come. So now in our constitution, we have very clear this rule that private markets are for private actors, and if the government is going to act as a matter of a public policy, it has to have relevant public interest for it, so it has to be reason, and it has to compete in same conditions.
Right.
So
Level playing
the law
field.
of contract, the employment law, and also taxation applies the same way to government and to public actors. So that framework has impacted Brazil's economic development. We do have some challenges, but I think I'll finish here, and I'll leave it for our
Thank you,
last
thank you,
round.
and appreciate that laying out. I actually have a follow-up question, but I'm going to put it into the asking everyone on challenges based on something that you had said, and just a hint, it's on the final judgment issue in independent judiciaries, which I think is something that we may all be struggling with. Before we go to, I'll do kind of one round of questions to get your different perspectives on the same question, but I first want to come back to Igor, because we had jumped in. I neglected to point out that you're a Supreme Court judge on the commercial
Jurisdiction, yes.
cessation court, is that?
Cassation Commercial Court.
Right, court. And yet I'm still going to ask you about your reactions to what Jamie laid out in terms of the role of following the rule of law in security, in the security context. I noted, Jamie, if I'm right, you were speaking there just prior, as you said, to the Russian invasion. This has now been ongoing for some years. The courts in the country has obviously continued to function with daily governance, but at the same time that you're fighting a war, and I would say fighting a war against an invader that is not following the rule of law, as Jamie pointed out. So what have you observed of the kind of challenges of continuing to follow the path that Jamie described when you're in the midst of it?
See, I come from Ukraine, a country that over the past decade has faced with enormous challenges. Yesterday, our country once again come under attack by drones and missiles, and at the moment there is no electricity and water in Kyiv.
The cap.
Yeah, but the courts are working. Adherence to the law during this conflict is not only a moral imperative, but it's a strategic necessity. Yes? Because when the state strictly follow international humanitarian law and human rights standards, they maintain trust of the people, ensuring social unity and resilience. Also, they strengthen alliances as partners are more willing to provide the military and economic aid to a state that upholds shared values. and they undermine enemy propaganda. Yes, because by demonstrating a clear contrast between lawful behavior and aggression. Ukraine's approach to documenting war crimes, in example, even under extreme pressure, Ukrainian institutions are working to collect evidence. We also work with international courts and prosecute crimes domestically. This demonstrates to the world that Ukraine defends not only its territory but also international legal order. That's why I think that the rule of law is very important for all of us. And it seems to me that judges in our country acutely aware of the importance of independence and impartial justice in such difficult conditions. That's it.
Thank you. Impressive, given the challenges.
Thank you for the lovely line. There is no water or electricity in Kyiv, but the courts are working.
Yeah, and
Yeah.
thank you.
That will live on.
And also thank to the United States, because you give us generators that help the courts to work. Because without these generators, it will be impossible. As I mentioned before, we widely use different digital instruments, and video conferencing is one of them. So, as I am a judge of Supreme Court, I am in the bench every Wednesday, and 62% of all hearings were use video conferencing with the courts.
Yeah.
And it's the possibility for people to connect to the court and to ensure our possibility to resolve disputes in any way, even without electricity.
Thank you. I also just want to point out, I think it's worth noting the United States providing generators. That is a prime example of what we would call soft power that I think is often overlooked or underestimated by many people within the United States, that those generators are a very practical way to support the rule of law and the continued functioning of the rule of law.
Of course, but people, even at that time, people come to the court just to, I don't know, to get some food maybe, or to charge their devices.
So it's spread, right.
Yes, because
Which also goes to public trust in the courts, actually, if it's the source. Well, I appreciate that. What I'd like to do is go around at this point and have each of you describe, ideally in Jamie's one bullet point, maybe two, of what you would see as the greatest challenges that jurists are facing, either in your country or what you see around the world in ensuring respect for the rule of law. I'm going to do a sub-note on that because I was particularly struck, Janina, by how you spoke about one of the, as I understood it, one of the kind of constitutional changes in Brazil was that the bottom line, and you caveated it saying this may not seem so unusual. I think right now here the United States is struggling with this, that the government has to respect the final judgment of courts. So I'm curious in that context, as jurists, how much you anticipate when you're putting forward judgments, getting to a judgment that the government will respect. I would assume, coming from more political places here in the United States, that if I'm the Chief Justice of the U.S. Supreme Court, I'm trying to figure out both how I get to 6 or 7 judges being with me of the 9, and crafting an opinion in a way that makes it very hard for the executive branch to challenge. So I'm curious, in terms of maintaining the independence of a judiciary, how you ensure that the judgments that you're working on how you increase the chances that they will be seen as final judgments. Maybe that's not a challenge for you and your courts.
You mean after we deliver an opinion, if it's going to be upheld for higher court, or if it's going to be respected by the executive
By the
order?
executive.
Yeah, in Brazil, we can apply sanctions to the executive branch.
Do you control the enforcement of those sanctions, the judicial branch, or do you rely on the executive branch for enforcing?
Yeah, of course, he'll be informed of the order, and if he doesn't comply, and then courts can apply fees, daily fees, for agencies, for the executive branch. So this is, a type of constraint because they all have to pay at the end of the day. So, and also the officer that is representing, let's suppose, the executive branch, he can be, this is a crime, it's considered a crime in Brazil, not, complying with judicial orders, and he'll be investigated and he'll have to respond at the criminal bench. So sometimes we have to, make accountable the person that's in office. And as he is a public servant, because we have a huge administrative state in Brazil, we have some political appointments, but just, from, at the head positions, the staff that is ultimately the people that is responsible for complying with it. Sometimes they even to the head, they say, well, I'm sorry, I will comply because otherwise I'll have to respond to the criminal bench. And but of course, and the fees, and our civil procedure has a specific regulation that we can apply fees not only for the public servant, he'll pay out of his pocket, but also to the legal entity, let's say for the agency or the branch of the judiciary, of the executive. So we have these kind of techniques that helps us constrain public agents.
Thank you. Agnes, I want to turn to you next.
For Ghana, there is respect for court decisions by the executive. We have the commercial courts, and I have seen that most of the time the government loses cases against multinational companies, and the decisions of the courts are respected and enforced. So when it comes to respect for court decisions, it's not a major issue in Ghana. And also, it's also because of historical antecedents of the rule of law in Ghana. We have had issues where, prior to the 1992 Constitution, executive could openly in public, criticize court decisions and say that no courts can order me. So because of that, when we adopted the 1992 Constitution, there was a clear commitment to the ideals of the rule of law, which is contained in the preamble of the Constitution. The principles are reflected throughout in the Constitution. So recently, under the 1992 Constitution, the Supreme Court has had occasion to adjudicate 2 election petitions, which was highly charged and had the potential to destabilize the country. But then at the end of the day, they all respected the court decisions for us to have the peace that we want.
So let me ask you, for the 1992, to get to that kind of buy-in in 1992, how did that happen? And to recognize, I know you weren't on the bench at that point, but to recognize that there was that problem, having courts not being respected, having them be criticized publicly by the executive.
For the judiciary, because of our past and our history, we anything that will impair our independence, we guard against it. Because in 1982, we had a situation where 3 high court judges were abducted and killed from their homes. They were abducted and killed from their homes under a military rule. So there is a general consensus that we don't want to go back. This is a dark history that we don't want to revisit. So for Ghana, there is no other way than the rule of law. And consistently in Africa, we always place between the first and then the third in rule of law index. And it's always because of the role that the courts play. So we also ensure that our decisions are enforced by the executive. Where we have a challenge is a perception that the executive has some kind of influence because of the way our appointments, promotion, and then removal of justices are made.
Different than in Brazil.
Yes.
Interesting. Thanks.
Yes.
And either on the independent judiciary point, or if whatever you see as the greatest challenge now that judges are facing, and I'm going to come to Jamie, and then we'll go to questions from the
okay.
audience.
And, it seems to me we also can apply fees here, but the key is public trust. We have to increase our public trust because public trust is the heart of the judiciary. And that's why it seems to me that the main challenge is this a new challenge, these hybrid threats. Yes, it's disinformation campaigns and that aim to distract judicial institutions and spread distrust among the population. And also in our country, of course, because it's wartime conditions, it's personal security of the judges, especially judges that handling sensitive cases, they face threats to their lives and the lives of their families as well.
Actually, I want to follow up on that point, Jamie, when I come to you, because with judges in the United States, and at 35%, though, I just want to point out, approval rating, which is very low for the for that branch.
Very
You mentioned
low.
the military approval rating being very high, but it's come down for judges, and how that intertwines with this. But
How interesting that my concerns are your concerns. And that should tell us a lot about the relative state of the rule of law in different countries. So I made my list before, and what I heard, because I'm deaf, is 4 points, not 2. So my first is security. So the statistics are up by magnitudes of 800%, the threats to judges. We should care because we care about the safety of judges and their families, but we should also care because of the subtle influence that might have on outcomes if a judge feels intimidated and is either not aware that they're ruling in a different way because of that, or they're hesitant to rule in a way. So that's a rule of law issue and not just a physical safety issue. Dramatic increase. My second point is the credibility and respect of the courts, which is what you said, Igor. You said public trust is the heart of the judiciary. And for better or for worse, the judiciary in the United States has lost the public's trust and respect, as Mara has indicated in polling. And I think the greatest concern I see there is the perception amongst many now that courts are political and not legal. Now, I don't think that of federal district courts, but a portion of the American public perceives courts as part political, if not all political. And I think that has to do with the manner in which judges, especially Supreme Court justices, are selected and confirmed. And I think it has to do with the manner in which judges, and especially Supreme Court justices, have conducted themselves. And here it is across the spectrum, whatever one views about the politics or the perspectives, liberal or conservative. In the modern era, the recent era, justices have taken on a very public and sometimes political role in their speeches. And they can often be perceived as partisan. They may not intend that, but they're often perceived that way. Judges should wear black robes and not be seen, and not become public and political figures. That leads to the final 2. I had on my list as well, but this is a timeless issue, not a recent issue, is the enforcement question. And unlike Brazil, where the courts have independent civil in a civil law system, independent investigatory authority. Courts in the United States do not. They depend on the executive branch. But this is a timeless issue. This goes back to John Marshall, and it goes back to every judge in court since then. What if we issue an opinion and nobody follows it? And so that is an age-old problem, which is apparent today as well. And one of the issues is, when do you follow opinion? Must the Supreme Court decide all cases before it becomes a final decision? That's an issue and a challenge. I have views, but that requires 7 more hours of discussion. And then my final point is a new challenge. That was an old challenge that goes back to the original, to the Judiciary Act of 1789. The new challenge for courts is artificial intelligence. How do we use it? When do we use it? Why do we use it? And this audience should be aware that the federal judiciary is looking at this with deliberate care. I was going to speak at the Federal Appellate Judicial Conference in 2 weeks on the topic of AI and how judges should use it. And unfortunately, the conference was canceled because of the shutdown. But back to your line, the courts are still working on that issue nonetheless. And one of the challenges with strength and weakness of courts, its strength is they're all independent. No judge serves under another. There's a hierarchy, but every judge is independent. So on AI, if there's 5 judges on a court, there's 5 views about how to use it or whether to use it. That can be a good thing, but it also is harder to establish uniform standards. We can establish uniform standards in the rules of evidence, but not in whether judges should use AI to decide cases, to augment human judgment, and so on. My answer, of course, is whatever you do, do it transparently, and always the human makes the decision. Thank you.
Thank you very much. Now let's open it up to questions from the audience. Oh, did you want to follow up on?
Yeah.
I do.
Yeah,
I
I
just want to make sure we get to audience questions too. But
Okay. No, okay, so I think I'll leave to the audience and then I can
And then
jump
come
in
back
if
in.
it's okay.
there should be someone mysteriously with a microphone. Here we go.
Or everyone.
Yeah, and then we'll come to you. And please just introduce yourself when you ask your question.
Yes, my name is Jamila Mohammed, a judge of the Court of Appeal from Kenya. Thank you for this great presentation. My question is to Agnes. Ghana has been hailed as a haven of peace. How would you tie up that to the rule of law? Because you are in the midst of conflict in many, many situations.
That is correct. Ghana has been hailed as a beacon of democracy and the most peaceful country in Africa. And it's all because of the rule of law, as we have discussed. We have not had any large-scale conflict in Ghana, and we have not gone to war before with any country. In the midst of instability in the region, Ghana has remained stable. And it's always also because of independent judiciary, the courts that are willing to check executive excesses and then the activities of the police in arbitrary arrest and all those matters. So it's as a result of an independent judiciary and our willingness to always ensure that we have peace in the country.
Thank you.
Thank you. My name is Aisha. I'm a judge from Tanzania. And my question is addressed to Yega. In Tanzania, just like in Ukraine, we have implemented the electronic management court system as part of the reforms to fight corruption. And digitizing courts has helped us in minimizing human interaction and some of the corrupt practices which are involved in manual or paper-based court process. However, we face challenges like connectivity, electricity, and cyber attacks. And I remember one day I was doing a virtual court hearing and the power went off, and I didn't want to adjourn the case, and I had to rush home to continue with the case. Now, I would like to understand, under the martial law, considering the war situation in Ukraine, how does the digitizing court process work in relation to internet connectivity? And second, how do you deal with cyber attacks?
Okay. According to our constitution, the rights to judicial protection cannot be limited even during martial law. That's why all these assistant technologies, they help us not only to be transparent, but also to give an opportunity to the parties to take part in the hearings. As I mentioned before, generators help us a lot. Also, what else? All this system that we now have, for example, to give, for example, a request to the court, or you can send any documents through email. It's also possible. That's why you can use any electronic devices that you have. And also, last year we adopted a new code of the judicial ethics, and we have a special article that you can use judges can use artificial intelligence, but only if it's not against the law. Yes, because as we were studied at university, the justice is the art of goodness and fairness. That's why I agree with James that any assistant technology is only like a supporting thing. Yes, it's like a tool, but the final decision it always been on the side of the judge. Yeah.
Cybersecurity?
Cybersecurity, yes. As I mentioned before, our country works a lot in this sphere because cybersecurity is like a part of our security of the whole country. Yes, we have several cyber attacks on all state organizations, not only to the courts, but we deal well. We're still working. Yes. As I mentioned before, this Ministry of Digitalization, they have a special department who protect us in this sphere, who help us, and also we have a special cyber department, we can name it, in police. In police, they also, from one side, they protect us, and from other side they do investigations against these guys who try to influence. Yes. Thank you.
Please.
Jump in with a two-finger here to just say Russia is also targeting the U.S. judiciary with cyber attacks. We tend not to focus on that, but they're very active in trying to penetrate the federal judiciary. And one judiciary that does cybersecurity very well is the South Korean judiciary. Mm-hmm. They've put the Supreme Court of South Korea, in charge of it. Mm-hmm. They have a fantastic team that does it, and they get daily practice because North Korea spends all of its life trying to hack into their court system. So if anybody is thinking about judicial cybersecurity, including in the U.S., talk to the South Koreans.
Mm-hmm. Thanks, interesting. I think right over here, this gentleman.
I would like, my name is Andrew and I'm from Ukraine. I'm a commercial court judge, but I would like to ask Mr. Baker about just like military courts and the courts for armed forces. You know, here in Ukraine, just decades before, years before, we had the military courts already. So we had the military prosecutors' offices and whatever, and there were no war in Ukraine. Now we have a war, and we do not have any military courts. We do not have any military prosecutors. So from your perspective, do you think it's necessary to have one? What the differences you just like can advise? From your perspective, do you think military judges or judges from military courts should have some experience serving for military, for army service, or they can be just like civilians, but very highly, just like educated and experienced judges from just another branches of
May I
court.
add
Thank
a
you.
little bit? Yes, there is an active discussion nowadays in Ukraine. It's very active discussion. Do we really need to re-establish these courts and specialized prosecutors? Because it costs a lot for the state. Yes, that's why there is a discussion. That's why it's a really nice question.
In Brazil, we have military courts, and there's the same discussion, just.
So all on you now, Jamie.
Sure. Yes, I visited Brazil, your military court, your president, and I learned that down in Brazil, the president of their court is known as your lordship.
It's not going to happen.
I brought that back to my court, and it was not well received. But I did try. George Washington. Every time I've gone to Ukraine, I've tried to pitch to them the necessity of having an independent bar of military lawyers. You can have rule of law, but you're relying on the good fortune of leadership without military lawyers. How many JAGs do we have? We have 5,000 military lawyers. They deploy down to the battalion level in the Marine Corps and the regimental level in the Army. Rule of law in the military, in the U.S. military, is not an accident. It's the daily work of judge advocates. There's confusion about whether military lawyers impede the mission or assist the mission. There's no question, in my view, they assist the mission. We all know lawyers who are nervous and get in the way. My response is, get yourself a new lawyer and I'll train them. The duty of the lawyer is to get to yes with honor, with the nation well taken care of and the Constitution intact. Just down the street, the JAG School teaches that daily, our JAG School. So every time I write a paper about the importance of independent military lawyers or the importance of a military judicial system to a nation at war, I send it to my friends in Ukraine who translate it into Ukrainian and send it on. Do you need a three-level court system like we have in the military justice system? The adjutant general of Ghana came to my court one day and visited, and she said, we're trying to reform our military justice system, but everybody in the United States tells me to set up a three-level system of appeal that looks just like yours. And she said, do you know how many lawyers I have in the entire armed forces of Ghana? 5. How can we set up 14 layers of courts? So it has to be tailored to the circumstances. But the difference, I heard when I was in Ukraine that it was a war between a large Soviet army fighting a small Soviet army. And if you're going to make yourself a democratic army, not a Soviet army, you need lawyers and you need the rule of law. And good on Ukraine for adhering to the rule of law, but a professional military has lawyers. So yes on that. Do you need military experience to sit on a court? My court does not have that requirement. I was a Marine Corps infantry officer, which comes out periodically as I talk. But in my view, at least in an adversarial system, you're in a civil system. In an adversarial system, it's the duty of counsel to bring to the judge's attention what they need to know. I don't accept that you need to have served in the military to understand the military. One reason we have an independent military justice system in the United States is worldwide deployments, the size of the armed forces, but also the thought that in some contexts, not all, it's important to understand the military context. If you're judging the conduct of someone on the battlefield, it's important to understand the pressures of the battlefield. It looks very different than it does in peace. But I don't think you have to serve 20 years in the military to understand that. The way we deal with that in our system is the members, the jury, is comprised of military members. So they bring the knowledge of what it was like on the battlefield and why split-second decisions might go this way or that way. Or, as we've seen in the United States military, why we don't want that person who shot the detainee in the head in our armed forces. Those people have been turned in by their own peers. So I hope that, so the answer is yes. I've offered to come over and talk to anybody in your country about how to do it at your scale and your context, because you're going to be in some form of either hybrid or kinetic war with Russia for decades. And so you have to play the long game, not the short game. When I go over there and I say, do something about your veteran system, they say, wait for victory. I'm like, no wait for victory. You got to do it now and play the long game. And military justice is one of them. Not Soviet military justice, Western, modern, democratic military justice. That's an emphatic yes.
So
Thank you.
we are at time. I want to thank everyone in the room and online, and particularly thank those we have here at the table. Yes, for your participation today, but really for your service as well in your countries and here in the United States. In the case of Jamie, I've learned a tremendous amount from you. I hope that everyone here has as well, and I really thank you for the work that you do and your dedication to it. Thank you.
Our pleasure.
Thank you.